Good morning, everyone. We just wanted to thank everyone for coming to this event. It's being co-sponsored by the Classical Liberal Institute, the Center on Civil Justice, and NYU's Journal of Law and Business.
We want to thank all of our panelists for participating. We look forward to very interesting conversations throughout the day. A special thank you to Chief Judge Wood as well for giving our keynote address. And lastly, a huge thank you to our moderators, Professor Arthur Miller and Professor Richard Epstein.
Please note that this event is being recorded, so if anyone has any concerns, just feel free to contact one of us. And please look out for the Journal of Law and Business's spring issue, which will feature an article by our panelist, Dr. Talid El-Zabawi.
Thank you all again for coming, and now David Siffert from CCJ.
Thank you so much. Really appreciate your all being here relatively early in the morning. Thank you to Gabrielle and Haley. They've done a really wonderful job organizing this event. I also want to send apologies from our director, Peter Zimroth, who can't be here this morning to give these introductory remarks, but he wanted to say that he'll be here later, and thank you all for coming very much. And again, thank you very much to the Classical Liberal Institute and the Journal of Law and Business. They put an enormous amount of work into it and did a really great job.
The equal time, please. Well, I want to thank you all. I actually helped him on a paper, but I don't want to mention that now. My name is Richard Epstein. I'll be the moderator on the afternoon panel, which will deal with the regulatory, medical, and reform issues right now. I just would like to welcome you on behalf of the Classical Liberal Institute, and myself and my co-director, Mario Rizzo, and Laura Creste, who's sitting in the rear of the room, have done so much to make this go. We always think that litigation is a kind of a prism through which you could evaluate the larger social purposes in any given organization, and we hope that we'll bring some enlightenment to this issue with the two panels that we have today. So with that said, I'm going to turn it over to the master of procedure, the wizardry of all art, the class action king, Arthur Miller.
Who?
He's also a Yankee fan.
Thank you, Richard. It's nice to be here. This is a lovely room. As usual, the front row is almost empty, but I've noticed that for about 60 years now, that's always the case. I have no stake in this litigation. I represent no one. I'm not involved in it. Indeed, the last 24 hours have been a bit of a learning experience for me in trying to get some sense of this. And I guess I'm up here only because I'm a director of the Center for Civil Justice, which is interested in all sorts of procedural things, and this is the big kid in town. Now, I want to know about you. How many of you are students? Don't worry, I'm not calling on anybody. I just want to get a sense of the audience. Richard is a student. We have a gaggle of students over there, a couple back there. How many of you are practicing lawyers? Practicing lawyers. How many of you are here just because you're sort of interested in the subject for some reason not connected with the law? Okay, okay. So, first thing we've got to do is figure out who's up here. Why don't I start with you, David? Who are you and why are you here?
Well, I'm here, first of all, because my torts professor, Mr. Richard Epstein, suggested that I might have an interest in that the panel would benefit from my presence. So that's the immediate cause for my being here. I'm a partner at Paul Weiss. I've been involved in mass torts since the late 1980s. It's been a major part of my practice, and I've represented defendants both before trial and particularly at trial. I tried several mass tort cases to juries over the years.
And your connection with this litigation?
Well, I represent one of the founding families of Purdue, Dr. Raymond Sackler's family, and that's my role. among other lawyers, of course.
Okay, I'm trying to position for the audience the cast of characters. Sheila?
Well, I guess I'm one of those characters. I'm Sheila Birnbaum. I'm a partner in Deckert. I used to teach torts at NYU and products liability and mass torts. I guess besides Joe Rice sitting next to me, I know as much about the opioid litigation as anyone in the country, having represented and still representing, of course, Purdue, who is in the center of this litigation and the controversy. So I think I can bring public insights to the discussion we're going to have. And Joe Rice and I have been in opposition in many, many mass torts, and I think we would agree at least on one thing, that this is the most complex, interesting one that has ever occurred in this country, and the impact of what happens here will affect tort law going forward, I believe, for the next 20 years.
So you're only going to give us public insights? Who's going to give us the private insights?
I'll give that to you.
And once Joe does that, then I will have to respond, so we'll
To be clear, these are at least my remarks, and I'm assuming for the others, I'm speaking of my personal views. I'm not speaking on behalf of my clients, and I generally don't speak on behalf of my clients in functions like this. And I say that because the media interest in this litigation is massive, and I want to be clear that my views that I'm saying today are simply my own.
And let me just add one more thing. I mean, this litigation is hot and heavy, as they say. I mean, sitting here this morning, there have been two major decisions that have already come down this morning. So if you're engaged in this litigation, there's hardly a day that goes by that not only do decisions come down and filings occur, but remember, this is a nationwide litigation that is in an MDL, of course, in Cleveland, in which there are over 2,000 cases filed, plus state court cases, plus AG cases, plus city and county cases, hospitals, tribes, insurance companies, and we'll get into many of these issues as we move forward.
Joe?
My name's Joe Rice. I'm from South Carolina. I practice with Motley Rice, and I have grown up in the mass tort world. I started practicing in 1979 in asbestos practice, where I had cases with Sheila and David. Then I started doing pharma litigation as that asbestos people decided to file bankruptcy. I was fortunate enough to be involved as the lead negotiator in the tobacco litigation, which David was involved in. And then I was fortunate enough to become lead negotiator in the BP oil spill case. Then did the Takata bankruptcy, Volkswagen class negotiation, and now I am co-lead counsel in the MDL on behalf of the federally filed cases. And Sheila will point this out if I don't. I also represent 9 of the state attorney generals, and I have cases in state court as well. So I'm a little bit involved in the opioid case.
I get a feeling that our panel is composed of people who have been involved in every bad thing that has happened in the United States.
But only on the side of fixing the bad conduct.
Jonathan?
Yeah, so my name's Jonathan Novak, and I'm on the panel because I'm from Texas, and every panel has to have a Texan. That's not true.
Not in New York.
Now, I have a different perspective up here, although I'm active in this litigation, both on the federal level as well as we represent a state in state court. My firm also is part of the leadership of the Texas MDL, which is very similar to the federal MDL, but just involving the counties and the state of Texas. But the real reason they invited me is because prior to everyone else jumping on board with the cool new litigation, I was doing this work for DEA for years. So I was a government litigator and regulator, and a lot of the work that we're looking at now, a lot of the causes of action are born from the work that was done at DEA and from the CSA and the CFR and how those have been interpreted over the years. So I will try not to be the boring government regulator. I'm no longer a boring government regulator, just boring, but in private practice. But that's the perspective I'll be bringing today.
Now, is everybody here? Are any of you represent individuals?
There are very few individuals that are suing in these cases, Arthur. There are some class actions that have been filed on behalf of neonatals whose mothers were addicted, and the class action issues have not yet been briefed in the MDL on that. But we're not talking here about individuals suing companies.
Except, I represent one personal injury case in South Carolina where we sued the doctors and the local folks in large part to bring attention to the problem in our community, because we were showing doctors just making prescriptions, and some defendants, some manufacturers are in there. But we're now in the bankruptcy court. And in the bankruptcy court, it's people that have a claim pursuant to bankruptcy law, which doesn't have to necessarily be a fully manifested claim and may not go through the same rigorous review that it would go through in a court. So in the instance bankruptcy, we saw immediately upon the bankruptcy filing a significant number of law firms come forward saying they represented personal injury claimants to try to get a significant role in the unsecured creditors committee, because the U.S. trustee has ruled in that case, and I anticipate it will be done in the Purdue case, that governmental entities cannot sit on the official committee of unsecured creditors in bankruptcy, which is the committee that normally manages the bankruptcy from the creditor side. So what you've got here now in the bankruptcy setting that we didn't have in the litigation is we're going to have new potential claimants that are going to have a significant role depending on how that committee gets created, which is being created today. So we don't know.
Let me just add one thing. The interesting footnote, I guess, is many years ago, there was a previous opioid litigation against Purdue in which there were mostly individuals. And a number of those cases were tried, most of them, if not all of them, I think, to a defense verdict because addicts are very difficult people to sue companies, and when they do, and you get into their history and background, you find that there's a lot of things that occurred that they never brought to the fore that does not help their causation cases, among other things. So that whole litigation ended with a settlement, a very relatively small settlement, and for years there was no litigation. So Joe's right, the bankruptcy may change some of the equation, but it's in a different form.
One last question for the audience. How many of you are not lawyers? A lot of not lawyers. So we have to watch out for jargon.
Yes?
Otherwise, we end up talking to each other, and that's incredibly boring.
Well, maybe
Maybe that's what we should do, right?
well, maybe we ought to, because of that, sort of set the stage a little.
Okay.
Talk about what this litigation is about.
Okay.
We just jumped into the middle.
I'm going to go back before the litigation. Jonathan, you're the right person to respond to this. It's called a crisis.
Yes, sir.
What the hell does that mean?
Well, in 2017, over 72,000 Americans died of overdoses. That's a significant number of human beings, Americans, dying from overdoses. The fact is, America consumes 85% or more of the opioids in the world. Canada doesn't have this problem. Germany doesn't have this problem. England doesn't have this problem. Japan doesn't have this problem. This goes back, and we can get into how it starts, but at the end of the day, there was a normalization of an incredibly dangerous, addictive drug. A normalization and a demand not only from the public, I want that drug, I hear that drug is great, but there was a demand by doctors, there was a demand by pharmacies to carry it, there was a demand by doctors to prescribe it. Everyone got on board. The crisis is that we normalize something so dangerous and it's killing us, and it's hobbling our workforce, and it's taking money that is in our communities and it's going towards Narcan and emergency responders instead of that money going towards bridges and schools and things like that. It's a crisis on all levels of the society.
David?
I don't think that there's really any question that's been raised by anybody in this litigation, but that there's a crisis, and it's been ongoing, evolving. It's a crisis that really progress has been made in some instances to mitigate it. The best minds in the country, public health authorities, independent researchers, people working hard on the ground, including the DEA, have worked extremely hard to figure out how to deal with this crisis. Nobody in the litigation questions that. I think the real reason that we're here at this law school and with this panel is to talk about whether the solution to that crisis really lies in the private litigation system, in a particular way that the litigation has evolved. Yeah. So there's no question about the crisis. The issue is civil litigation the solution to a public health crisis? And I don't think it is.
Well, I think you got to go back and look at what the allegations are and why the lawsuits were filed against the parties that they're filed against.
Now, what's the theory of the case?
Right. So there's many causes of action, but I think they centralize around this story. And I know my colleagues will have some differences with me. But there became a point in time when the manufacturing community decided that what should happen in our pharma world is we should start actively marketing drugs and narcotic drugs. And in order to actively market, they hired huge marketing staffs and created a massive industry of marketing in narcotics. And then the allegations go that in doing so, they began to mislead and provide inappropriate information, insufficient information, et cetera. In 2008, that led to a criminal indictment of some manufacturers and some representatives. And they pled guilty to that criminal indictment of fraud and misconduct in the marketing of their drugs. But by that time, the pharmaceutical industry, the distributors, and the doctors had been given a 6 to 8 year education that these were miracle drugs. These narcotics should be used for any kind of pain, including everyday chronic pain. So if you got a sore knee, if you got a bad back, if you got arthritis, you should be taking opioids. And then there was this concept of pseudo-addiction, in that when people came to you as the doctor and sought help because they were addicted, it really wasn't addiction. It was you were under-treating the pain. And therefore, the remedy for that was to give them more and higher doses. Then there's a question as to whether the efficacy of the drug and whether, limited release or controlled release was really controlled release. There's arguments about whether or not, and to the extent there was knowledge of the ability to easily abuse the products. And then you get away from the manufacturers and you get into the distribution. And the distribution, anybody that transfers a narcotic drug in our country under DEA regulations has to report to the DEA where that pill goes. And they're supposed to report it, and they're not allowed to ship the pill or send, fulfill an order that's suspicious. And if the order is suspicious, they have the obligation to investigate before they ship. Not ship and then investigate, but investigate before you ship. So the allegations are that when you move from the pharma world to the distribution world, that manufacturing world to distribution, that they failed to comply with their DEA responsibility, and they shipped. And this is where you start seeing in the press, in the ARCOS data that's been made public, the Washington Post did a good job of putting that stuff out, that you get millions and millions of pills going into communities of 100,000 people or 10,000 people, which just in common sense, there's no legitimate reason that a community of 100,000, like Huntington, West Virginia, and Cabell County, should be getting millions of opioid pills a year. And then you'll get to the question, well, somebody was prescribing them, and then you got doctors, and then you got misuse of prescriptions, and then you've got pain pills or pain mills and pill mills that were created. And then you get to the last segment, which is the pharmaceutical industry, the distributors, the dispensers, Walgreens, Walmart, the big pharmacies. Every time anybody in here goes into their drugstore to get a prescription, you have to give them some kind of information, your insurance card or something. They type it in, they pull up all the information about you. And they know when you get your prescriptions, who your insurance, your copay, the last time you got a prescription, how many prescriptions you've had in the last 6 days, 6 months. They've got all that information at their fingertips. Yet we see medical records and pharmaceutical records where the same pharmacy chain was filling 90-day prescriptions for opioids to the same individual 5 times a month. So in 1 month, this person was getting 5 times what the prescription rate was. So there's a whole litany of actions that sort of piled on, like in football, you pile on, it's a penalty. And I think that's sort of the theory of the case. And there's responsibility at different levels, and there's different levels of responsibility.
Can I, yeah, let me get us back.
This is like Rashomon. Everybody has a different perspective.
You know, let's look at the real history of this.
You be the jury.
I'll bet on you guys anytime to be the jury. Pain in this country was totally undertreated for many, many years. This is not the lawyers saying this. This is medical community. There was no really emphasis on treating chronic pain. There was this development of this new type of opioid that was an extended release opioid. Now remember, you have the FDA. FDA has to approve every drug, including this. You have DEA that sets the standards for how many opioids can be sold in this country in any year. That's done by the government, not by the companies. Companies can't make more than the government tells them to make. So what happens? There are warnings. We forget about warnings. Professor Sharpie and I were just talking about warnings this morning. There's a warning on every one of these prescriptions that this is addictive, that this shouldn't be misused, that this shouldn't be crushed, that this shouldn't be snorted. And everybody knew what they were doing because everybody in the chain, including the cities, the counties, the states, the federal government, saw what was happening out there. This is not about opioids that are being prescribed properly and used by patients. This is about opioids that are being misused and abused by people who are trying to get high. And what they did was what Joe says was right. People went to doctors in their community. They went to 6 or 7 doctors. They got these pills. What did they do? They sold them, or they used them themselves to get high. So we're not talking in the whole about use. We're talking about abuse and misuse. And today when you hear 56,000 people, or whatever the number is, die every year from opioid overdoses, go and look at those numbers. They're not dying from prescription opioids today, or since 2016 or 17. They're dying from illegal fentanyl that is coming in from China and heroin that's coming in from Mexico. And that's what's killing people today.
Respectfully, I I just disagree with that message entirely, but I won't get into that.
What
I
a
will say-
surprise, what a surprise.
I do understand that is surprising. I will say this, in December, my brother graduated to heroin after 10 years of opioid addiction, getting pills first from his doctor, then when he didn't have insurance anymore, getting them from people off the street because he was addicted. I do not, as much as I understand the message, and I respect, and I've been going up against that message for years, but there's a undercurrent of blaming the victims to what you're saying that it's just not my experience, having done this for years. The victims of this epidemic are not drug-seeking junkies. They are high school students who were injured, and the doctor was taught that a standard prescription for oxycodone 30 milligram pills was a 30-day supply, and he re-ups every single time, and suddenly a year later, that kid is in jail for possession of heroin, or he's dead. Those are the victims of this, and to paint the portrait as anything other than the people who ended up addicted didn't intend to get addicted and were misled about the safety of these pills, I cannot disagree with that stance strongly enough. Again, obviously not surprising.
David?
So I think now everybody sees that from what has just been said so far, that there are two different kinds of worlds here and a real difficult problem to solve. And the two sides are really very profound and kind of simply stated, but it's very difficult to reconcile them. So there are 50 million people every year who suffer from chronic pain. 50 million. 20 of those people have what's called high impact pain, which means it affects their activities of daily living. It's a little jargon, but I think everybody gets the idea. But to bring it home, these are people who, when they get up in the morning, they're in pain. That's all that's on the top of their mind is their pain. Every minute of every waking day, they are in pain. And when they go to sleep, they know that they won't be able to sleep well because they're in pain. And when they know that when they get up in the morning, they will still be in pain. And prescription opioids today are an essential, the FDA believes, they're an essential medication for meeting the needs of these people. Then you have the problem of people who do not follow, don't get it by prescription, or they don't follow the prescription. And nobody is blaming a person who takes opioids to solve a pain problem and becomes addicted. That's not really the issue today. The issue is, what do you do about the fact that the addiction then leads them, and it's a problem, there's no question about it, to then take pills not under prescription. And so you got two groups of people who have an enormous, profound problem. The medication plays a key role, but the medication has risk. And the key word, that key word, is balance. Who strikes the balance? Who strikes that balance? And the answer in the United States today is the FDA. And the FDA, since these pills came on the market decades ago and more recently in the 90s when the undertreatment of pain was recognized, they absolutely recognized this undertreatment. They recognized the risk of addiction and abuse, and they struck a balance. That's what the FDA is supposed to do, and they approved these drugs as safe and effective, and they remain safe and effective today. Now, we can go back over those 20 years and find lots of fault, lots of things that happened that weren't good. But we come back to this room, in this building, and the question here, which is whether in civil litigation we're going to find a better resolution to that fundamental problem than what the people at the DEA, the FDA, the state health authorities, what they've tried to do for the last 20 years, particularly when, as Sheila indicates, prescription opioids it have tapered off dramatically, but particularly extended release, which were only a small part of the marketplace. Today is a fentanyl problem. It's a huge problem. This stuff is unbelievably potent. And yet right in the middle of this fentanyl crisis, All these states and all these counties are out saying, oh, we're going to solve the crisis, we're going to sue a bunch of people and dig up what happened 20 years ago and pretend like there's illumination for how to solve the problem of today. That's a legal problem, and that's what I think that we really need to focus on. Has the legal system done well so far in somehow trying to displace the judgment of independent public health authorities?
So
I
are we
think we've
trying
got
to
a good
blame
history.
Jonathan and all of his
No,
federal
I
friends?
would
Where
never.
the hell have you been?
On this point, actually, I fully agree. The difference is the regulators, the agencies who are tasked with overseeing this, were asleep on the job, were incompetent at best at times, were absolutely influenced by not only political but also personal interest in what comes next after I leave this agency, because a big law firm or a big pharmaceutical company is coming and knocking on my door saying, well, you're an expert on this, why don't you come and work for us? And suddenly you have a self-interest in maybe not bringing as many cases, maybe not regulating as stiffly as you could have. I think that DEA reacted to this too late, and then at the height of everything, when DEA started going higher up the food chain, DEA stopped regulating entirely. And to say that these experts, that somehow they were independent in viewing this and trying to solve this problem is ludicrous. There were so many outside influences weighing on FDA and DEA from 1996 through when I left DEA in 2015. You could see it. You could see the slowdown happening in the middle of a big crisis. It just happened to coincide with when DEA started going after distributors instead of just taking down bad doctors. Suddenly, there seems to be a lot more influence on who DEA is going after and how often they're going after people.
Joe, I sense that some of your panel colleagues, particularly those to the right, which seems appropriate, are trying to point fingers elsewhere.
I think that the proof is in the pudding here. I think David's got a good point to say the word balance is something we should talk about. But I think he is pointing fingers and not reviewing balance. I think the balance is the balance between the rights of corporations to manufacture and sell products and to make a profit, and the balance of the corporate responsibility to do so honestly, forthright, and not under fraudulent and misconduct. And I think that the juries are a good place to determine what is the right balance. So when you get into the question of the FDA and the DEA, then you get into politics. Then you get into who's got the money and what's going to happen at the logic-free zone of America, which is what I call the Capitol. And we've got a good history here because for 20 years, Congress did nothing to deal with the tobacco epidemic we had. And the civil justice system came and started filing suits to enforce the laws and enforce corporate responsibility. And after about 3 or 4 years of litigation, there was a settlement. And that settlement was intended to target conduct that was inappropriately directing cigarette use to kids and inappropriately using flavoring and cartoon characters and things of that nature. And there was a resolution. And since that time, the smoking in our country among kids dropped dramatically. And the health rate of smoking-related injuries dropped dramatically. Now, we've got this recent flip on vaping that is probably going to end up in another litigation, whether it's going to be against the same tobacco companies or not.
Spoiler, it is. It absolutely is, guys.
You could use possibly, but that would even more profit.
We're just a little busy these days
know.
right now.
I'm sure you're winding up.
The B team's at work, I promise you. But
To the paralegals.
so it is a question of what was proper conduct and what was proper exercise of your rights and what proper responsibility. And we're going to have jurors sitting there, and they're going to listen to these stories And they're going to hear, it's the FDA let us do it, and the DEA let us do it, and they're going to hear about the contributions to political candidates and how many former DEA agents or FDA high officials are employed in the pharma industry and what their job was and all their email traffic. And one thing this case is different than tobacco or asbestos or most of the mass torts that we saw before 2000. It's technology. There's been 161 million documents produced in the MDL litigation. The number of emails, and I urge you, if you're in an emotional state or whether you think you're having fun with a colleague, be careful what you put in an email, because someday somebody's going to read it and you're not going to be happy with what you said.
The one advice I always give people about emails is think of your email. Before you press send, read it again, especially when you're hot under the collar, and say, what would this look 10 feet tall in a courtroom? And then you'll go back and you'll rewrite the email. And believe me, the things you see in emails.
This is actually a public document, so I'm not talking out of school on this
Can
one.
I ask Joe a question?
Yeah.
Is that right?
You can ask me a question.
No, I was asking.
Wait. I
Professor.
thought Joe was going to give us an anecdote.
I am.
Oh, okay.
There is a series of emails between a vendor selling opioids, like a pharmacy store, and a high official of marketing for a distribution company, where the discussion is, these pills are flying out of here. We need more pills. They're flying out like Doritos. They're flying out like they are addictive. And the marketing director says, oh, they are. That is in a series of emails. Flying out like they're Doritos and they're addictive.
Can I go back?
You can ask your question.
I forgot the question. Well, I'll read just a short question / statement. So Joe is an unbelievably capable lawyer. He is, among all the people I've been.
Stop, you don't have to tell
up
about
against.
it.
Joe's the
No,
best.
Sheila, he's sneaking up on Joe.
No. Sheila completely agrees. So, juries. So the FDA, the DEA, they have the ability to take scientific evidence, to hold conferences, to make decisions that are written and are forever, and they are uniform across the country. Everybody has got to follow what the FDA says. Everybody has got to follow what the DEA says. So now we're going to take the same issues, these huge issues affecting millions of people, and I love the jury system. I'm a huge believer. I'd often rather have a jury than a judge. But I'd rather have the FDA make decisions about health and safety rather than juries. But
He called them incompetent.
well,
At best. I said incompetent at best.
But I don't think that when he was at the DEA, he would have called the DEA incompetent. But I want to go
At the end of my tenure, I would have.
I want to go.
Well, you should have been a whistleblower.
I want to go to
I
the
was.
jury. I want to go.
All right. So now
I
you
love
know.
it when they talk dirty.
I want to go back to the legal issue here, this institutional legal issue, which is, if you actually take a look at the litigation today and what's happening today, and it's not the first time, this goes back to breast implants in the 1990s. Are these
We've
cases?
been around for a long
Yeah,
time.
and it's the same problem. So you got companies, they go from motion practice to summary judgment in 8 months. Everything is decided in this litigation.
Was that your first client that went in bankruptcy?
What?
That was-
No, I'm going to get to the bankruptcies in a minute, but the juries. So do they really want these cases to go to the jury? The answer is no. They don't want these cases to go to the jury. So the way that they assure that that's true is they come up with theories like public nuisance to displace the 50 years of law on products liability and FDA approval and what it means. They go that way. They go to the way of bellwether trials. So you're a company and you're facing 12 to 15 jury trials in the space of, say, 12 months, And the damages sought in each one of those cases take 2 counties, just 2 counties in Ohio. In the MDL case that's coming up for trial, they have got statistical models, and that is a gracious statement about them, to calculate the damages for those 2 counties in the billions and billions of dollars. Now, how many companies have the wherewithal or the sophistication to go from $10 billion to $5 million to $50 billion trials all in the space of 12 months? And the answer is they don't. And so the real purpose of this, the real purpose is not to do justice before a jury. That's simply a tool, it's a threat, is to get people to pay up. And to pay up not on the basis of a real recourse to the law, but on the basis of the fact that they cannot, simply cannot afford to go through the process. And what's their recourse? Bankruptcy. There are 93 mass tort bankruptcies in the last 20 or 30 years, and they're happening now with regularity. Is that a jury system? Is that juries doing the work of the FDA? Or is it the jury threat that does the work of the litigation system, which is designed to simply produce money?
All right, you folks have now completed your opening statements. Thinking about the litigation, is Judge Wood here yet? Okay. It was a private joke because David just sounded like one of her colleagues. Remember Roan Palank and Judge Posner?
Yes, the coercive effect
It's an
of class
inside joke,
certification.
folks.
No, that's
an
an
inside joke.
Judge Posner and Roan Palank, yes.
What are the problems you face? You've heard the rhetoric.
What are the problems defendants face or plaintiffs?
Plaintiffs. Let's start with plaintiffs.
Well, they don't have a good cause of action.
I asked Joe, Sheila, not you.
I think the rulings on the motions to dismiss throughout the country pretty much say we do have good causes of action.
That's not what they said.
But there's a lot of fault to go around. There are causation issues, and when you look at each defendant, there's different stories to tell. They got in the business at different times. They did different things. There's different market shares. And, you know, there are going to be empty chairs at a trial. Purdue is now going to be an empty chair. So there's been so much press and so much discussion about the Purdue and the conduct and the 2008 criminal plea, et cetera. I'm sure that the co-defendants now in trial are going to be saying, you were right all along, Purdue is the responsible party, they did this, they started this. So there's going to be causation issues, there's going to be legal issues on whether or not public nuisance is a viable cause of action, although it's been around for hundreds of years, and the Supreme Court within the last year rejected the cert petition in the California lead case that they could have taken if they thought that public nuisance was going to be misused. My firm tried the California lead case and prevailed against the lead industry on lead paint poisoning. And it went to the Supreme Court of California, and they affirmed it, went to the federal appeals process, and the Supreme Court denied cert. And that was in, I think, 2017. So the theory of public nuisance is a solid legal theory that's been part of our common law and statutory law for hundreds of years, and I don't think it's going away. RICO was developed to deal with, you know, racketeering and coercive combined conduct. Civil conspiracy is a civil litigation tool that's been around. So I don't think the causes of action are a problem, but there are going to be people on jurors, and the defendants are going to argue it's the bad doctors, or it's the fentanyl, or it's the illegal drugs, and those are issues that we'll put out. What they can't run from is their own documents, and I think that's where the difference is going to be, is their documents that are damning.
How are you getting through all that stuff?
Not easily.
Not easily from either side. I mean, it's massively expensive to do mass torts today because of the document production. The cost of a defendant to go through the emails, 15 years worth of emails and 15 years worth of documents, and call them out, produce them, check them for privilege, check them for confidentiality, mark them for, you know, business, trade secrets, et cetera. It's an expensive, time-consuming process. once we get them, to challenge all of their inappropriate designations of confidentiality, et cetera, and to put them all together. We don't get them in nice, neat chronological order by subject matter. They shuffle the deck. And that's, I guess, is fair. So we then have hundreds of lawyers that have spent thousands of hours just doing nothing but going through documents and coding them. Then you have to have electronic search tools. So in mass torts today, the discovery process and the electronic search process, it has made the cost just astronomical for both sides.
Sheila, what are your obstacles? And don't say none.
No, of course there are obstacles. That's why we're using bankruptcy as a settlement tool. It's just the mass nature of it. No company can, except, a huge company can fight 2,000 plus lawsuits in state and federal court with state agencies and cities and counties. And if you try 5 cases and you win, you got 2,000 cases left, and sooner or later you're going to lose. So, and the numbers are staggering that the plaintiffs are getting back. So, Joe's right. Just in producing documents, it is an incredibly mass, hundreds, millions and millions and millions of dollars are just spent on trying to get the emails. And this is in every large litigation now, because there are so many emails, and you got to go through them all, from all the people who had anything that touched anything. So that's a real problem. But the issue here is really causation. And, it's sort of just think about what's happening. The plaintiffs allege that the manufacturers misrepresented to who? Doctors. Because this has never been advertised. You never saw an advertisement for an opioid. You can't advertise opioids. So this is not like a pharmaceutical drug where you're watching on TV, go to your doctor and ask your doctor for a drug. This goes to doctors. Any detailing, they call it detailing, and all pharmaceutical drugs are detailed to doctors. People come in, talk to the doctors, especially early on, and tell them what the product does. And they have to follow certain instructions that the FDA requires. You have to leave certain materials. You have to talk about the risks. You have to talk about the benefits. So, are there any doctors in these cases that are being called? They say my client misrepresented to doctors. Well, they don't call a doctor. This is not about, in an individual case, if you said there was a person who took your drug and you misrepresented to the doctor the benefits or risks of the drug, you got to bring the doctor in, right? There are no doctors here. And in fact, when we take depositions of doctors from time to time, you find they know all about the addictive qualities of opioids. You have to be under a rock. Everybody knows opioids are addictive. So there's a causation issue. So by having this is all new, guys. Cities and counties are suing. Thousands of cities and counties are suing. State AGs are suing. By the way, there is a great deal of issues that are happening now in the Sixth Circuit. There's a mandamus petition of whether city and counties in Ohio even have a right to bring a cause of action, because only the state AG has the right to bring the cause of action. And there's a mandamus in the Sixth Circuit. Yesterday, the Sixth Circuit asked the plaintiffs and the judge to respond to the mandamus from the Ohio AG. So there's a lot of real issues. Who does this cause of action belong to even? Who has standing to bring it? The AGs, they're bringing it for all the people of the state? Well, the cities and counties, they say, well, we have separate damages. And in public nuisance, this is about abatement. This is not about past damages, perhaps, maybe abatement in the future. What are we abating? So there are some really important legal issues that are going to have to be decided by appellate courts after trials, because that's the only where it's going to get sorted out.
Sheila, are you afraid of juries?
No, I'll tell you, it really concerns me when I see lawyers asking for judge trials on public nuisance when they're plaintiff's lawyers. Have you ever heard a plaintiff's lawyer asking for a judge to try the case rather than a jury? That bothers me more than the fact of going to a jury. I think it's a very hard case for a defendant to try in front of a jury because of all of the mass publicity that has gone on already in these cases. And you can't tell people, you ask people, have you read about this? Do you know about this? Everybody knows about the opioid epidemic. So it's hard cases to try.
Yeah,
But I hope we're going to try some.
Yes.
My client won't.
Yeah.
Unfortunately.
You'll be there in spirit.
I've tried mass tort cases for over 35 years to juries, and I'm an enormous believer in the system. Juries have the ability to cut through complexity and bring common sense, but the principal virtue of a jury is it's 12 people, not one. And their only job is to decide the case. They don't have to decide what happens to the future of the world. They have to decide the case in front of them. And I'm an enormous believer in it, and I've tried very difficult cases, some of the cases that we're talking about here, before juries, and we've met with some success. The problem, though, is that no jury trial is better than the law and the instructions and the rulings from the court make it. And the real problem here, and it's not just opioids, it's a problem of mass torts. I mean, over 50% of the claims, individual claims, that are now pending in federal court are tort cases. Why does that happen? Because there's been a huge increase in the number of mass tort claims. So you see, testosterone. I was involved in the testosterone litigation. You see all kinds of fairly well accepted, commonly used medications that are now the subject of mass tort personal injury claims.
Talcum powder.
What?
Talcum powder.
Sure.
Talcum powder is another one of the interesting wrinkles, but yes, talcum powder. Roundup. Roundup's been on the market for 40 years. The EPA just said, I'm sorry, it's not carcinogenic. But we got cases all over the country, and we got jury trials. The difficulty is that in this particular case, and it's not unique, but in other cases as well, there's this enormous pressure, and there's a solution to it. There's enormous pressure on the MDL judges or any judges who have got a number of cases to get to a settlement.
We have a lot of people here who are not lawyers. Tell them what an MDL is.
Yeah, so an MDL is multi-district litigation. So it's a fabulous, fabulous idea and tool. And what this involves is that every case that's in federal court that involves essentially the same issues can be consolidated before one judge in one court all over the United States. And that decision is made by a panel of judges, very high-quality, sophisticated panel of judges. So they end up before one judge. So now the MDL judge has the authority and responsibility to deal with all pretrial matters in that case, and all the cases on a consolidated one-time basis. So over 50% of the claims in federal court are personal injury claims, largely, overwhelmingly in MDLs. And what does that judge want to do? He wants to get, or she wants to get, resolution. She wants to get, or he wants to get, a settlement. And it's become a conventional common practice today for judges in MDLs to basically encourage a very prompt pretrial process and then set up these bellwether trials. Why? Because everybody knows that when you get a lot of trials, maybe you get settlements. But one thing that's been sacrificed in the process is that this whole litigation is now going to be essentially tried or settled through this bellwether process. This is generally the way that it works. Well, the problem is that there is no appeal. There is no appeal from all those pretrial rulings unless the MDL judge decides to certify matters to the Court of Appeals, which incidentally holds up the process, so there is no provision for it.
Oh, you
And the
can
result-
always take mandamus, and
Well,
aren't there
but-
mandamuses in the Sixth Circuit today about
Every day,
Judge Polster?
there's been several mandamuses filed.
But I don't think that anybody would say that we ought to have mandamus built in as the mechanism. So now it's time to think about how to get interlocutory rulings before the gauntlet comes into place, to take issues like public nuisance, where the fact of FDA approval, the fact of doctors, as Sheila indicates, all that gets obliterated because you treat it like, and lead is nothing like pharmaceutical products. Property damage, public nuisance is a property damage idea, and it's strict liability, essentially. You do something on your property that hurts mine, you pay, period. There's no role for the doctor, there's no role for the patient, and we just have models that calculate up how much the damage is, and all of the complexity that's built into products liability law over the last 50 years is obliterated in favor of public nuisance, and that's what the plaintiffs want to try. They don't want to try the doctor, they don't want to try any of that. They just want to say, you put this product over the border into our state or our county, pay up, here's a statistical model that proves how much it's going to cost to fix.
We're going to trial on civil conspiracy, we're going to trial on RICO, and we're going to trial on public nuisance, all causes of action. We wanted to go to trial on damages, but the court wanted us to narrow to 3 causes of action, so those are the ones we picked. These cases are about damages.
Okay, let me back up and put it in perspective. Again, for the normal people in the room who are not lawyers. We got all of this federal stuff put into Cleveland, Ohio, before a judge who had a pretty good procedure course when he was in law school because he was my student. So I vouch for him.
Now I know who to blame.
Thank you. Now, let's notice a couple of things. Number one, it's only the federal cases, right? It's not the state cases. Number two, in theory, it's only for pretrial purposes. But now, as David properly points out, the culture of MDL litigation is to produce these things called bellwethers. You may recall a bellwether is a sheep leading the flock. Now, you can say that's a good thing, you can say it's a bad thing, you can say he shouldn't do it or she shouldn't do it because it was only sent to you for pretrial purposes. Or you can say, as David did, the objective is to get a global settlement for the rest of the cases. So you got these two, is it 2 bellwethers up in the Sixth Circuit now?
There are
No.
There's
not,
one case, two counties.
Summit and Cuyahoga counties are the 2 plaintiffs in the bellwether
Are
trial.
they going to go to trial?
Yes,
When are they going to go to trial?
October 26th,
first.
first.
So that's pretty close.
Yes, it's
Yeah.
around the corner.
Everybody ready? All you
Nobody's
folks-
ready.
Nobody's ready.
They'll have to be ready.
Sounds like my class. Nobody's prepared.
But how long will it take? Let's assume that case goes to trial, goes to verdict. There's then post-trial motions, it goes on appeal.
Right.
By the time that appeal is resolved, how many other bellwether cases will have been put up for trial? The answer is, let's assume it's resolved in 18 months. The answer is almost the entire bellwether docket that's currently set, both in state and in federal court trials every month, will already have passed. How many companies are going to be around at that point in time without having settled before the first appellate court gets to pass on the issues in the case? And the answer is, if all goes well for the plaintiff's effort, and there's no blame, none of them will be around, or maybe 1 or 2. Maybe Johnson & Johnson will have weathered the storm. Everybody else is going to be out. Then there may be more bankruptcies. We don't know.
Joe, he's saying that you're sowing the seeds of the destruction of American capitalism.
No, it's
No, it's creating it.
It's destruction of the law being applied consistently and taking a little bit of time to have courts of appeals pass on these issues. Maybe even having an amendment to the rules, which the Rules Committee has been considering for God knows how long, that says we should have interlocutory appeals in MDLs, because then you can get guidance before you go down the path of trying all these cases. Why not find out whether public nuisance is viable? Why not find out if RICO should be applied? RICO in the tobacco litigation, huge jurisprudence that says you can't do what's being done with RICO in these cases. And yet, the whole learning of the tobacco litigation, which took years and had multiple federal decisions saying you got to prove causation the old-fashioned way, for some reason, we don't have that now in opioids.
We filed the
That's a
first.
problem.
We filed the first tobacco case in '94 and settled in '98.
Yeah, and there were multiple, there were, first of all,
Right.
it was against 50 years of trying cases.
Right.
And there were trials that took place in that litigation then and thereafter.
Other processes are pretty slow. Look, Jonathan fooled around for 20 years and did nothing. If you can solve tobacco in 4 years, that's great.
So let's talk about the multi-district litigation. And David identifies issues that the defendants raise. I think defendants use the multi-district litigation as an offensive tool to slow down litigation, and they're attempting to continue to do that. I think that many times people support transferring cases to the MDL too early. I believe the opioid MDL was created too early. I think if the federal district courts around the country had kept the cases until they got through the motions to dismiss, which is generally in the early part of a case, then there may have been some inconsistent rulings, and we may have had a dispute. But right now, we got no legal dispute because all the rulings have been consistent, both in state and federal court, except for 2 attorney general actions in North
North
Dakota
Dakota.
and Connecticut.
No, Connecticut was the municipalities, but close.
Okay. Connecticut, the home of Purdue,
Right.
said that you couldn't sue Purdue for this.
Hasn't said-
Don't be bitter, Joe.
I'm not bitter.
It's only Connecticut. You got 49
I don't
other
need it.
states.
I like unanimous.
But I think that the MDL process is a good process at the right time. But I do think that mass torts, sometimes the MDL has been used to create a mass tort versus to resolve a mass tort. And I have spoken at MDL conferences and to MDL judges and said, be cautious of quickly transferring cases to one place because it centralizes, yes, but it gives opportunity to slow walk it, and it limits the rulings that you can get because one judge can only handle so much. So I prefer to see, in a month before the MDL petition was filed in the opioid case, I spoke at an AAJ conference, and my topic was, do MDL or not to MDL? And I said, absolutely do not MDL this case right now. It would be the worst thing that can happen to us to find out how the case really looks. And
Well, certain of the plaintiffs moved.
they moved, you're right.
MDL.
You're right. Plaintiffs moved forward and the industry joined 100%. And then they limited themselves to one judge in one jurisdiction and the MDL process. They knew that when they asked for the MDL.
Can I raise another issue which I think is interesting and important to this audience? That is that the judge has approved something close to your heart, Arthur, and that is
I have no heart.
whatever is in the place of your heart. A negotiating clause.
Yes.
I knew you wanted me to raise that.
No, I'm glad you did. I was going to.
And Sam, the audience knows, has been involved in this from the beginning. Part of the problem in settling these cases is the fact that there are 23,000 or more cities and counties. And there are over 2,000 in the MDL. But how do you get closure? For defendants, if you're going to settle, you want to have a global resolution and you want to be done with the litigation. And there doesn't seem to have arisen a procedural basis in the class action toolbox that fits this. We've examined it, plaintiffs and defendants, over a long period of time. No one was happy with 23A, 23, the kinds of things that can get mandatory class action, and you don't have to have opt-outs. And I think defendants were very concerned that if you had a 23B3 opt-out class, that there would be many opt-outs or enough opt-outs that you could get global resolution, and there would have to be a second negotiation. So a lot of legal minds in the class action field came together in a number of meetings and thought processes. And arising out of that was something that is not approved by the Rules Committee, or for that matter, any committee, and it's called a negotiating class, and it takes a little from here and a little from there, and it says that you can have a 23B3 opt-out class, but if 75% of the class votes in favor of a settlement, that would bind the other 25%. And you have to decide before you know if there's any settlement, whether you're in and out of this sort of process. So it takes a little from bankruptcy, a little from Sam's works on aggregate liability for the ALI, and there is this negotiating class. It's been preliminarily approved. Notice will go out, or has gone out already?
Gone out.
Notice has gone out.
Notices, yeah, they went out this week.
And we will see what happens. And there is now a 23F petition that is either going to be filed or will be filed.
Of course,
Circuit.
of course, and that'll
But-
take how many months?
Two of them? Happened.
Now, Joe,
And they filed it
So-
yesterday? Today?
Yes. One was filed last night, and the other one filed this morning.
I guess I didn't get my emails yet.
So the class is a little different than Sheila described it in one concept. The class recognizes that there's roughly 3,000 municipalities that have filed suit, both in state and federal court. And then there's 30+ thousand that have not. So in order to get approval, you have two separate votes. You have the vote of the litigating parties that have to approve, and you have the vote of the non-litigating, so neither side can override the other and force an issue. So there is that additional protection in there. It is a novel approach. My role in the MDL is I'm involved in most of the resolution discussions. And it was a big problem that the defendant said, Joe, how can you give us closure? You want us to pay all this money, but then we settle the 26,000 federal cases, we're going to get 2,600 settled cases, we get 2,600 more. And that's a legitimate question. I'm not sure it's true that that would happen, because if those people intended to sue, I'm not sure they wouldn't have already done so, and then by delaying, there's all kind of issues get raised and all. But it was a tool that they wanted. And the only thing that we could come up with is to create a mechanism to provide some level of assurance that if the deal was fair, people are prepared to speak together and take it. But the question of whether or not the deal is fair is the second question that will be presented to the class. So all the class does is create a voting mechanism to approve each individual settlement one at a time. And you can approve one and reject the other. It's no cram down. And the theory is if 75%, we use that because it's a rule in bankruptcy and a special legislative provision for asbestos litigation, that if 75% of the people by volume and value support it, it's probably the right thing to do.
you think you can get that? 75%?
Sure.
Yeah.
I mean, you
that's
sound
not
as
hard.
if you're impeaching somebody.
No, it's 75%. Look, I will say, I think that Sam and others have done a very sophisticated and really a very excellent job of putting together this kind of proposal. I mean, it shows a lot of imagination. It's not in the rules, maybe it'll become part of the rules. But all that I would say, to bring this back to the real benchmark, which is what's fair, is that if you do something like that, you empower the people in a huge way who have the bulk of the cases, because they'll have the bulk of the votes. And so you'll get the 75%, because there are a relatively small number of lawyers who have the skill, the wherewithal, and the profile and brand to be able to get this. So as you think about that, which I think is a very interesting idea, you still have to come back to the question, well, what assures fairness? And fairness is not the 75% that's voting. Indeed, that 75% will give them enormous leverage in the settlement, because what is it that they now have to negotiate with? They've got closure. Nothing will be more valuable to the defendants than closure. That's when the dollars go up. So this is an interesting idea, but you then have to say, well, what's the benchmark for a settlement? And I'll go to another interlocutor many years ago who asked a question. He is almost as good as you are, Arthur, and that's Ken Feinberg. And this was at the Georgetown conference. He used to have those in the 90s. And the question on the floor was, well, how do you tell whether a settlement is fair? And of course, everybody, when they have a settlement, they'll all say, well, I think it's fair for X, Y, Z. But in our system, there's only one real determinant of whether a settlement is fair, and that is whether the people who are settling actually do have recourse to a litigation process that it's got the wherewithal to do what needs to be done. That assures that people have a choice when they settle. You get to litigate or you get to settle. And if they got the choice to litigate and on a meaningful basis that is accessible to them, that's the best determinant of fairness. So this does not solve. This solves a problem, but it doesn't solve the problem that we've been talking about today.
Jonathan, I may be wrong, but your name is not on the brief submitted to the judge on this negotiation claim.
That's correct. My name is not.
What's your impression as a theoretical outsider?
So there's two parts of this, and the first is, and I agree with my colleagues up here entirely, we're breaking new ground, and we're looking for fairness. This is a novel idea. No one's ever done anything like this. And starting from the only way that settlement is even possible is with closure. I completely agree. Closure is what has to occur. You can't have more potential lawsuits hanging out there. But also, it's one of the most complicated ideas to express from one lawyer to another, let alone to express to my clients who are not lawyers, to understand exactly how this works, to understand the nuts and bolts of it. It's either really dressed up and impressing me by being so dressed up, or it's really, really impressive and well-written and well thought through. And I'm absolutely certain that this is a really well thought out idea. But I completely agree on the one hand that because this is new, it's not easy to hang your hat on it. It's not. And I represent some clients who have filed in state court. And we are looped in on that process through the head of our group and who worked with the MDL team to at least to understand what's going on and everything and passing that on. So we feel that we have a voice in it, and it's thinking of our interests as well. But this is a point that I was going to make earlier. It seems like we all have bought in. It seems like we all want to go in this direction. This is the best solution. But yet systematically, it's questioned by defense counsel. The process is questioned. The fairness of this is questioned. The MDL process is questioned. Because at the end of the day, while we're on the plaintiff's side trying to tell a story and trying to help and fix a systematic problem, at the end of the day, it seems that the defendants are going on board, they're marching in line with this, but at the same time, they want that freedom to question the system so that they can then appeal the entire thing. They're not voicing that right now when they have the opportunity. They didn't voice, for instance, that they felt that maybe the judge coming out and proposing settlement right out of the gate with this MDL, that issue wasn't raised until further down the line when things didn't seem to be going their way. I think that's really, for me, the sticking point on all this is if people are fully against it, I want to hear why, and I want to hear right now. And instead, we're all agreeing to this very complicated thing, and then people will complain later.
Well, this is not.
That's not true. I mean, some of the defendants did object immediately. They put in briefs. The AGs objected immediately, put in briefs. So it's very clear right from the beginning of this action who is for it and who is against it. And I think
But
if I'm a betting person, I think the Sixth Circuit may take this in the 23F because it's so unusual, and I think they need to do it. If they do it sooner than later, I think that will give more solace to people that this would work or not work. I think otherwise, you're going to have a very drawn-out affair, and until there's a settlement, and then if someone objects to it, it goes up, you're not going to know the answer to the question. So,
and you're probably going to say, and all the litigation should be stayed while that goes up for the next 2 years.
I'm not in the litigation anymore. I'm just giving you my professional
You're so
opinion.
cynical, Joe. You're so cynical.
So while this is a novel approach,
Yes, Joe's name is on the request for
Right.
this certification.
and my name's also on as class counsel in Georgine and Amchem that went to the U.S. Supreme Court that were also novel approaches in creating
Yeah.
Rule 23 class settlements. And those both were rejected, but rejected for different reasons, but the tool has been approved and accepted. So we do have Rule 23 class action settlements as settlement classes, is a tool that's been used. We used it successfully in BP. So
Pretty controversial, but yes.
But Joe is right.
That's right.
Apropos of something you said, David, the rule itself, which I've read once or twice, does not provide for settlement classes. It provides for settlement.
You'll have to see. So we have a Ninth Circuit decision in the Hyundai case with a very strong dissent that talks about Amchem. You have the Third Circuit that approved the NFL case, applied the requirements for Rule 23 to a settlement class. So it kind of does the fact that a settlement really make a difference. But that issue really has yet to percolate up, which is under the existing rule.
except the
really have
Supreme
some-
Court didn't take the BP cert petition.
Well, but that was for a variety of reasons.
All this
Yeah, it didn't have any
technical
merit other than that. So I'm going to go back to
I
the,
want closure,
All right.
unless you have a really significant footnote at this point.
I do have one,
Oh.
and I hope you deem it
Why am I not
significant after the
surprised?
fact. I
Go
mean,
ahead, Joe.
David said earlier that this case wasn't about damages, but what is at the heart of this case is the economic destruction in Main Street, United States, that this opioid epidemic has caused. And the reason that you've got 2,600 or 3,000 municipalities that have stepped out and filed suit, the first case was filed in 2014 by Santa Clara County on behalf of a number of California municipalities and counties. In 2015, a city of Chicago filed. And there weren't but 4 or 5 cases until we get into 2016. And then there weren't any Attorney General actions until we get into 2016 timeframe. And what happened is people in the small town of America were seeing, they were having to make decisions about whether to hire a school teacher to put in the elementary school or hire another police officer to put in the jail because they were having so much opioid-related crime, addiction, deaths. They were having to spend twice their budget, increase their budget twice for the morgue, because the economics were falling on small-town America. And when you're a business or corporation thinking about relocating a plant, and you go and you look at different places and you got options, and you pick up the newspaper while you're there to meet with the mayor, and it talks about 3 more overdose deaths last night or 5 robberies for this, that impacts whether you're going to decide to go to that community or not. So these municipalities had no choice but to come forward and say, we have to have help to address this before we destroy small town America. And so this case is about economics. It's about economics on Main Street, and it's about economics and damages. It just so happens this first case is saying, we're going to focus on getting money to help abate the problem, to stop it from growing. We still have the issue of how to rebuild these towns and these communities and how to deal with the absence of enough foster care to deal with NAS babies and all that. So these cases are about damages as well.
It was mentioned before, I'll mention it again. There is a series of articles in the Washington Post that does a brilliant job of showing the demography of opioid impact in the United States. So if you're interested in this subject, it's well worth reading. Now, I want closure from you. It's their turn. Questions, comments, observations, no hard objects. You're very agitated about this.
Hi, thanks to you and the panel. My name is Jennifer Oliva. I'm an associate professor of law at Seton Hall, and I represent the amici curiae American public health and medicine scholars on the MDL. One of the things that wasn't discussed today was how impactful the tobacco settlement was insofar as the release of documents. Many people agree, including my client, that it wasn't the money that had a huge impact on tobacco cessation, because most of the states spent the money on capital projects and other things. They didn't spend the money on tobacco cessation measures. The southern states, in fact, spent a majority of their money on tobacco subsidies. So my question, I guess, is really directed at Joe and anyone else on the panel who wants to answer it. Have you read our briefs, and are you negotiating to get those documents out into the public so it's transparent and mimics the positive effects of the settlement in the tobacco litigation?
There were two things when we were negotiating the tobacco settlement that became fundamentally key elements for the attorney generals that were at the negotiating table with me. And number one was the release of the documents. And they would not settle for the economics without the release of the documents. And the second was a little bit more controversial, is they wanted to create a fund that they knew was going to be used for education. And that's where the Truth Initiative came from. And it was controversial because generally attorney generals take the position that they have the authority to bring money into the state by way of litigation, but they don't have authority to appropriate funds. So the fact that some of the money was set, I think it was $300 million, but I'm not sure, was set aside was a key element. The fact that the tobacco money did not get used to address the tobacco problem is one of the principal reasons we have this litigation today that is being pursued by the municipalities level, because they do want to insist that the money be used on the opioid epidemic. I'll give the attorney generals credit here because most of the attorney generals agree this is a different kind of case and the money should be used to address the epidemic. There is a dispute as to who should control what that means, but that's it.
Well, let me respond to
But wait a
that.
minute, let me finish.
Oh, okay. Thought you were.
But absolutely, never. Absolutely, transparency is a key element here as well, because how we got into this mess, how the system failed, and if there was manipulation of the system, we need to disclose that so it doesn't happen again. And I think that Sheila will tell you that in discussions that we've had with her client, getting transparency on the documents and making them publicly available is a key element, yes.
Well, let me just answer your question. I did read your brief, by the way, and I thought it was very interesting. Joe did say he read it, but that's all right. Because I know he didn't, but I did.
I was a little busy reading all your mandamus petitions.
That's right, that's right. I do that too. So let me just say from my client's position, we are not and have not and will not enter into an agreement of settlement where the money goes into general treasuries of cities or states. If you have followed our settlement in Oklahoma, we insisted, and the AG agreed, that the money went into a foundation, University of Oklahoma, State University of Oklahoma, to be used in a foundation for treatment and for research and for education. And the bulk of the money went for that purpose. And in any other settlements, the money, and by the way, a footnote to history, when we did that settlement and it got completed, very soon thereafter, the Oklahoma legislature has passed legislation that can't happen again, that any settlements have to go into the public treasury. So this is a lot of politics. Maybe you ought to put your efforts with the political people that don't want this to happen, that don't want it to go to the right places for treatment, for education, for research. And put your pressure there, because the politicians want the money for their own purposes in many places. So we're committed to that. This company has been committed to any settlement being all used for the right purposes, for the purposes of dealing with addiction.
Questions?
We were talking in the opening remarks, I believe there was mention of, the various defendants across the opioid supply chain and how there will be sort of varying levels of culpability and liability ultimately. And I was wondering if maybe you could elaborate as to how you see that the sort of respective culpability or liability across those various categories.
I will answer that by referring back, but I'm not going to answer it directly to the opioid case because I think it borderlines on some things I'm not supposed to talk about. In the asbestos litigation in 1982, Johns Manville filed bankruptcy. And they had 16,000 cases filed against them when they filed. And they said it was an overwhelming burden, and they filed for bankruptcy. At that time, there were probably 7 or 8, maybe 9 additional defendants in the asbestos world. As lawyers started working harder and digging more and learning more about the facts and learning more about what had happened over the years, you started seeing more defendants. And now I think there's probably at least 100 corporations that are sometime regional, sometime national, that at one time or another have been involved in the asbestos litigation. This is a massive problem. It's a problem that's going to be with us for a long time. So I expect that there's going to continue to be information come to light about what one corporation may or may not have done right or wrong. And it would not surprise me to see additional parties and segments of the industry involved in this litigation before it's over with. And Sheila, I won't tell you who they are, so you can go to it.
Too busy.
But I think you know.
Too busy.
Go ahead.
Sure. Very much appreciate that, each one of you is very knowledgeable, and but what it appeared is that you guys are just hiding behind procedure. The real issue over here, which we saw also in the financial crisis, that we have privatized the profits and we want to socialize the losses. Just to give you an idea over here, that the public, I have no dog in the hunt over here. I've just read what Professor Miller said. The publicly available information, some of the emails that have come out from the Sacklers, they're devastating if those are true and accurately reported.
Name one. What do you think is that you read that was devastating?
Basically acknowledging that we know what this product does.
Everybody knows what the product does. It's addictive.
But we have to keep on pumping to make the profit. And these are publicly available information, and I'm not taking any sides. But look over here, even on the panel, the bankruptcy has been filed by Purdue, and they want to shield the Sacklers. Now, in the bankruptcy, what I have done, what I have seen, there is no such thing to protect a shareholder from that.
Yeah.
And so what I'm basically saying is that right now over here, there's a lot of discussion how to make the case as if they are just innocent victims. But profits have been made. And now if you see that even attempts were made by the Sacklers to take some of that money out, which the New York Attorney General has done. So the important thing over here is that there is a huge public policy crisis. And what we heard over here is, oh gee, there was an empire. But when the empire is not neutral, when the empire is conflicted, the same way it happened in the financial crisis.
All right, is there a question?
The question over here, no, the question over here is that we want to socialize the losses and we want to privatize the profits. And I think that's the real issue over here, that profits have been made and people don't want to, basically use that money and basically saying it's
So,
a public
I think-
health crisis, so the government should basically resolve it.
Yeah, I think I understand the question, and it's an interesting and it's a good question. The purpose of the judicial system is nothing to do with socialization of costs. The purpose of the judicial system on the civil side is to determine what should be paid by private parties under the law. And that's what we're all here about. Now, the Purdue case has gone into bankruptcy. And bankruptcy doesn't displace the law. It doesn't displace responsibility. It doesn't displace any of that. All that it does is to centralize everything before one court. And in that court, liabilities get determined, responsibility gets determined. That's the whole bankruptcy process is a critical process for resolving cases like this. That's why I mentioned earlier, there are over 90 mass tort bankruptcies that have been filed, not just asbestos, but pharmaceutical products and otherwise. And as to the Sackler families, and I represent one of the families, the Dr. Raymond Sackler family, the same applies to them. They're part of the bankruptcy. Their responsibilities get determined. And one of the things the bankruptcy does is it provides closure so that whatever liabilities are determined, they can be determined and then responsible parties pay. And the idea of including the Sacklers is nothing that's novel. I've represented third parties that have been shareholders or entities, parent entities. It is a standard part of the bankruptcy process that in order to get all parties that have some involvement in the liability that drives the bankruptcy in one place, you bring the third parties in, and guess what they have to do if they want to get closure? They have to pay for that closure. So nobody's hiding, nobody's trying to get a shield. Everybody wants to have a place where we can get closure on a fair and lawful basis.
I think, though, I think, just briefly, I think this speaks to something that this opioid litigation is a response to. And whether or not this could have been handled through government agencies, it wasn't. This lawsuit, the undercurrent of all of it, from every client I represent, is anger and accountability. And yes, it becomes about money, and yes, there are bankruptcies, and yes, some of the documents that come across our desks will not see the light of day. That's the nature of this. But I think at least I can speak for myself and hopefully for the other plaintiffs' attorneys, we are angry and we're trying hard to make sure that that voice is heard, that it's not just a shuffling and exchange of a check and then the whole thing's done. There's been so much coverage of this problem from the very beginning because everyone in this country is affected by this directly. And though that's not answering your question, I just want to make sure that that's part of what you're saying, and that's part of what everyone's saying. That's why we want to get those documents out. That's why we want this recovery. That's why the ARCOS information from DEA being published was so important.
Well, time is pretty much expired, and I lived through, I participated in asbestos, and I lived through and participated through tobacco. It's a slog. It is an incredible slog. And as some of the comments indicate, you hope you come out better from a societal point of view on the other side. But having watched a bad movie 3 times now, I fear that there'll be a 4th bad movie at some point in your lives. Not for me, All right, you have a break. I wanted to give you an upbeat note before we went to break. My thanks to them.